So today is, as I shared, a little bit different than normal. I'm not here presenting a topic. I'm here answering questions, and it's my pleasure to do so. As I shared, if you caught our introductory video on this, the whole concept of this thank you. The whole idea and concept of what we do here is to make sure and help our clients have a peace of mind and an understanding as to the different aspects of elder care and planning and taxation and asset protection that's going on within their lives and the lives of their loved ones. So the idea of just taking some time aside to answer questions from folks that may be clients or aren't clients, it's a new idea, and let's see how it works. Just for those that are clients and those that aren't clients, this me answering questions today is not it's not legal advice. There is no attorney-client relationship. This is just information that's educational in nature. I hope you understand that. And me answering your questions again, it's not legal advice. It can't be, even if you're a client, all right, because we're dealing with an open forum here. Okay, so this whole idea sprung a number of years ago, actually, and the idea was I had sat with a client a number of years ago, went to go sit at a kitchen table when we were able to do that pre-pandemic, and literally sit down with her, looking at her, face to face across the table. She was in a wheelchair, but she did in fact have a stack of questions. She had it folded paper, she had Post-its, she had envelopes with writing all over it, and on the top was literally the yellow Post-it you saw in our advertising. We had it duplicated, literally in her script handwriting. On the stack was there, "Ask Brian." And we stayed and we answered questions. We went back and forth, and as different thing popped up, I was able to help. And it's what we've done for years. I mean, my own grandmother used to make a list, Tina, as I've referenced in prior stories. My mom's mom, when we'd get together, as I was an attorney, of course, we got together for a lot of different things, but she would save her separate legal questions and aging questions and care questions. So it's something I enjoy doing. Now, we do have a number of questions, and that's a great start for our first time doing this. If you do have other questions as we progress during this, please feel free to stick them in the chat box. I will get to as many as I can in the time allotted. If not, join us next month for our next session number 2 on the Ask Brian Q&A. Okay, so here we go. First question came in from Jackie. The question is this: how does Medicaid assess an elderly person's ability to conduct the activities of daily living? So to put this in context, a lot of work that we do focuses on helping our older loved ones and aging clients receive the best care possible. And we utilize usually the Medicaid benefit, the Medicaid program, to do that. And when we're looking primarily at home care and receiving community Medicaid benefits, there has to be an assessment of the needs so that an amount of hours or level of care can be awarded. And what New York State's been using is something called a UAS. It's a uniform assessment system, a tool, so that there should be some level of consistency in the delivery of the program itself. But the question from Jackie is, how does Medicaid assess that? And yes, there's the tool. It's over 200 questions. But as the Medicaid application process is underway and the legal and the financial components are being addressed, there will then come the time for the care assessments. And in the community Medicaid world, we have 2 assessments as of now. Didn't have these in the past. These are all developments over the last 6 or 7 years. And the first assessment is what's called a conflict-free assessment. That's where a nurse comes in to determine whether or not the care is actually considered to be long-term in nature, which generally is agreed upon to mean 120 days or more, okay, of needing care. The long-term care community Medicaid program that I'm talking about is not about somebody breaking their ankle and they need help temporarily. Long-term care means greater than 120 days. So that's the first assessment. Then the second assessment is where the MLTCs become involved. The The MLTC stands for Managed Long-Term Care. That is the agency that receives the funds from New York State and then employs the home care agency, which of course employs the caregiver, the aide, to go into the home. Now, the MLTC system is what began 6 or 7 years ago, and that's how these assessments started to evolve. That MLTC assessment is all about, currently, really for the balance of this year, is all about the current functional limitations that a client has. When we say functional limitations, we're referring to the activities of daily living. Those are transferring, which means getting up and out of bed or getting out of a chair, walking, bathing, toileting, grooming, dressing, and eating. Those are the commonly accepted activities of daily living, or ADLs. And if you followed along with them in order, it's literally everything you did this morning. You get out of bed, you walk to the bathroom, you use the bathroom, you bathe, you groom, you dress, and you eat. And the assessment is gauging what level of care, how many hours of care does this applicant need. Now, the way we do it, and it's very unique and it's very helpful, is we have our elder care coordinators involved with each of these assessments. Our elder care coordinators are what sets us apart. We have our attorneys, we have our paralegals to do the protection work and the Medicaid work, but focusing as a team on the care issues and the assessments and the advocacy, and then the coordination of the benefits and the providers is what truly helps the families during these issues as they navigate that long-term care system. So the ADLs are all about the functional abilities. And to further on with Jackie's question, for example, she says, if a person can get around the house with a walker, but needs someone to always be nearby when they do so because they've had multiple falls and are unbalanced, could that qualify as needing assistance with walking or transferring? Or does the person have to be completely unable to walk? So the functional assessment is about independence or requiring assistance. And even using a cane, to a lesser extent, but using a walker, and therefore following that a wheelchair, is actually a need for the ADL, okay? So if there is a demonstration of need dealing with the walker, you're gonna qualify. That counts as a need with the activities of daily living. Now, currently, you need to demonstrate need with two of the ADLs. Come the new law next year, they're increasing that to an entirely different standard. But hopefully that answers your question, Jackie. Just the need and the use of a device should entirely count. And through advocacy and being that squeaky wheel, that's how we're able to have that count as an ADL to increase the hours our clients need. Next question. Then Alyssa asks, what is the difference between consumer-directed, what's called CDPAP, consumer-directed, you may have heard of that for the rest of you, and the New York State Waiver Program, which I understand is another program that provides elderly people with in-home care instead of the nursing home. So to explain what that is, while we're applying, and this is still in the world of community-based Medicaid, a traditional route is to pursue the MLTC avenue, which means that a home care agency will provide an aide, hopefully, to come in and help with the care needs, those activities of daily living. There are other avenues. CDPAP, consumer-directed, is one of them. That's where Medicaid realized that there's not enough aides in the world to help all the folks that actually need consistent functional assistance. So, and some folks just want family to do it versus an outsider. So consumer-directed means the consumer, the client, the family, the elder or their proxy or agent is actually going to direct the care. That's where consumer-directed comes from. And that means you're hiring your own aide. And it can be a child, it can be a neighbor, it can be somebody from down the block. Still have the assessments, still have the award of hours, but when you have a consumer-directed arrangement, you're in charge of the care. That person, that non-professional aide, does in fact have to, hang their hat, as I put it, with an agency to get paid from New York State through that agency. But it is a good way to stay in control of who's there and who's not there. There are a couple downsides. The biggest one is you're responsible for your aides. and if the aide is not able to make it, or then who's the backup, right? If you have an agency, then we've got somebody to call. So organizing and coordinating the first, second, and or third aid as a backup is an important thing to undertake in the world of consumer-directed. Now, consumer-directed level of care is going to be that custodial, functional assistance with the activities of daily living, compared to, as Alyssa is asking, with what's called the Waiver Program. And in the world of long-term care Medicaid, when somebody uses the word waiver, what they're usually referring to is the Nursing Home Transitions and Diversion Program. That is a program that was created a number of years ago to help people stay out of nursing homes or to leave nursing homes. But what that means is they need a nursing home level of care. The consumer-directed program is assistance with chronic activities of daily living underneath the waiver, underneath the nursing home level of care. A nursing home is going to be more of a skilled need, okay? So the two programs are not equal. You either go consumer-directed or you go with the waiver nursing home transitions and diversion program. There's more benefits provided, a different level of care, okay? Hopefully that answers your question, Alyssa. All right, Mary, let's see if we have what's going on here. We got couple more questions are piling in there. So the next question comes from Mary. Can an agent for a power of attorney also be the beneficiary in a will? So changing gears from community Medicaid and more toward estate planning. Estate planning is where we come in and help folks not only with documents, which we'll talk about in a moment, but the plan itself. What's the strategy? What's the big picture? Who's going to help? Who's going to be the backup decision makers? Who's going to inherit? How are they going to inherit? When are they going to inherit? That's what estate planning is about. And one of the most important tools we have is not just any old power of attorney, but a durable, modified power of attorney. Powers of attorney just this week have gone through significant changes. And if you've heard me before, you've heard me say that it's probably, again, one of the most important documents that exist. It's where you're able to appoint somebody to handle all of your legal and financial matters. However, that agent is bound by the four corners of the document. They can only do what's written in that document. So that's where the word modified comes in. If you have a power of attorney from LegalZoom or from Staples, that's not going to have modifications. That's not going to have the language necessary for when we get older. It won't have language for asset protection or income protection. It won't have Medicaid language. So the modifications that I refer to are those that deal with aging and elder care issues, okay? The idea of durability, that just means the power of attorney is going to remain valid should the principal, the one that signed it, become incapacitated, okay? So durable, modified power of attorney. If there is no power of attorney in place, or if the power of attorney is lacking the modifications, that can be a problem. If there's already a decrease in capacity and they're not able to sign a new power of attorney, you can be forced into what's called a guardianship proceeding, which you do not want to do. 6, 8, 10 months long opportunity for contests and problems, very expensive hearings, judges, lots of lawyers. So you can avoid all that guardianship process by having a durable, properly modified power of attorney. Now, your question, Mary, is can an agent of the power of attorney also be a beneficiary of the will? And the answer is yes. Quite often that's the case. When we're working with a mom and or dad putting together their plan, they can have 3 children and they may trust the middle child the most. That's going to be their executor. That'll be their trustee. That's going to be their power of attorney agent. But at the end of the day, that child, being a child, will also be a beneficiary. So a person can wear different hats. Can be a child, can be an executor hat, can be a trustee hat, can be a power of attorney hat. And when they're doing their different roles, they're wearing different hats. Okay, so hopefully that answers your question. A question from Lindsay. Hi, Brian. I've been told that when a spouse dies, all assets and resources automatically go to the surviving spouse. Is this true? How does naming beneficiaries, joint accounts, trusts, etc. affect this? Great question, and we cover this as well as all the power of attorney stuff in every consult when we talk with clients. When a client passes on, when your loved one ultimately passes on, there are 4 different ways in which our assets can be owned, as I explain it. You can have assets solely owned, you can have assets jointly owned, You can have assets and accounts, of course, with beneficiaries, or you can have assets owned by your trust. Different types of trust exist. We'll get into that another time. What I meant to say a moment ago is, if you have any questions or further questions about trusts or powers of attorney, Medicaid itself, go to tullyelderlaw.com. That's our website, Tully, T-U-L-L-Y, elderlaw.com. And there you'll be able to go to the video tab and see all of the webinars we've been doing for the past 14 months. Real in-depth as far as the powers of attorney, about asset protection and Medicaid work, and the Medicaid changes that are coming, okay? So that'll be there if you need a little more depth than what we're covering today. So again, when people pass, solely owned, jointly owned, beneficiary, or in trust. If there is a trust agreement that owns an asset or a piece of property, that trust will dictate what happens after the client, the loved one, passes on. So when you have a written agreement controlling the ownership and the usage, there's no need to go to what's called probate, okay? Probate is the court process, almost just as bad as the guardianship I was mentioning earlier, and it can be avoided. So a trust, as I'm sharing, avoids probate because the trust controls and owns and dictates the next owner. Moving up the list, I spoke about beneficiary. A beneficiary account, like an IRA or life insurance policy or an annuity, again, you're dictating the next owner already on your own with that beneficiary form. They fill out that claim form, they get the asset. Therefore, you don't need the courts to help you out at all. And when you have a joint asset, that is automatically, by what's called operation of law, passes to the joint owner by survivorship. And again, you don't need the court to assist at all. It's in that first instance, if you have something in your name solely, not joint, not beneficiary, and not in a trust, that's when you have not set up the next owner. Therefore, you have to probate the will or administer the estate, and 6, 7, 8 months of time, court filing fees, legal fees, potentially dragged out much longer than that, depending on the family circumstances. Now, you avoid this court probate proceeding by joint assets, beneficiary accounts and assets, and trusts, okay? Now, the specific question is, when a spouse dies, all assets and resources automatically go to the surviving spouse. Unfortunately, no and no. All assets and resources do not automatically go anywhere unless it's a joint account, okay? So if there is a married husband and wife or married spouses, what you're looking at is there a will, or are the accounts joint? So as I was sharing 2 minutes ago, when a person passes, if those accounts between spouses are in fact joint, then that's where they're going to go. And yes, it's going to be automatic. But if there's an IRA, there's a claim form, it's not automatic. There's a little process there. If there is no will and there is a spouse, then yes, the spouse will receive everything through a court proceeding called an administration, which is the proceeding when there's no will, but it's not automatic. It's a 5, 6, 7 month process. The only way for assets to automatically pass is joint. The other than that is beneficiaries and trusts. Now, if there is no will and you have a spouse and children, okay, again, there'll be an administration proceeding. It's what's called intestacy. When there is a will, it's called probate. When there is no will, it's called intestacy. And it happens a lot because people don't plan in advance, which is why I love doing these webinars, to try to convey and for you to share this with your loved ones so that they get the planning and the protection done before the issues arise. But if there is a spouse and children and no will, anything in that decedent's name, solely named, will go through intestacy. And the rules are, in general, the first $50,000 goes to the spouse, and then the balance is split up 50-50. You can run into some real problems with that if anybody is disabled or if anybody is a minor, then the court is appointing guardians. So you do not want to rely on anything automatically happening unless somebody like myself says, yes, this will automatically happen. You want to plan and you want to set it up so that you can have some assurance as to where assets are going to go, when are they going to get there, and how are they going to get there. Okay, so Lindsay, thank you for the question. Hopefully that helps. Question from Jennifer. What are the latest updates for community Medicaid? I've heard that the look back may still be only 1 to 3 months. Is that correct at this time? If I put money in trust to apply for Medicaid, can it be spent for assisted living? So let me break that up, Jennifer. And again, webinars on tullyelderlaw.com under the video tab cover all this in more depth. The idea of a look back period is when the Medicaid agency reviews all of the financial accounts to see if the person, how the person became eligible. If there was any asset protection done during the look back period, then a penalty will be imposed by Medicaid and they won't pay for a period of time. Now, gratefully, for the last number of decades, only the nursing home program has had a look back period. And it's varied in times, as in length, but since 2006, it's been a 5-year or 60-month look back period for every nursing home application has had this 5-year look back. And gratefully, on the other hand, home care has never had a look back period. But as you allude to in your question, and as I've talked about in prior webinars, community Medicaid is finally changing. I have colleagues in a lot of states throughout the country that do this work, and New York has been, they've been envious of New York because we could literally currently shelter all of our assets and apply for community Medicaid-based benefits like I was talking about earlier, where an aide can come in and help with those activities of daily living. And we can do that without a look back. We can do that without penalties. So we can have a $500,000 home. We can have $500,000 in the investment account. In June, transfer that out to a child or to an irrevocable asset protection trust and be eligible in July. That still exists currently. You're not approved in July because you've got the whole Medicaid application process, but you're eligible and we can start the process for application. Now, as I've shared, that's changing. Come January 1st, and by the way, this was supposed to change in 2020. It's supposed to change this year, but they've kept postponing it because of the pandemic. I don't think they're going to postpone it again because the pandemic, as we all know, has been dwindling. While it's still declared, it should be ending this year, the pandemic itself, the classification of the pandemic, which means the changes will be able to happen in January. And the changes do not apply to nursing home Medicaid. They only apply to community Medicaid. And what New York State is doing is finally creating a look back period. I'm not a fan of it. I wish we were able to keep the current system in place. But if they kept the current system in place, economically and budget-wise, they're going to keep driving the program into the ground. So there do need to be some kind of gauging of eligibility. So the look back period is going to be a 30-month window eventually. What this means is if there are any community-based Medicaid applications filed after January 1st of 22, there will in fact be a look back. The 30 months is not automatic, meaning they're not going back 2.5 years from January. What happens is the look back will begin for everybody as of October of 2020. So if you apply in January of 22, you'll have a 12, 13-month look back, okay? If you apply in February of 22, you'll have 1 month more. The 30 months will be phased in. So if, on the other hand, we have a healthier client these days and they do their asset protection planning now, the service is what we call an elder care protection plan, which is where we utilize this irrevocable trust, then that client will have 30 months going forward because they're not going to be applying for community Medicaid this year. They will be, in fact, applying for community Medicaid after the look back period is implemented January 1st of 2022. Okay, so in the big picture, when we're sitting with clients that have care needs now, we are conveying as strong as we can, do the planning, do the protection now, and apply for community Medicaid benefits with our assistance during 2021. And quite honestly, the sooner the better. I think everybody and their mother is going to be applying come the end of the year because of the new law that's being started January 1st, okay? So can it be spent for assisted livings? So how you protect is the answer to that question. If assets go into a typical asset protection trust, then in order for that to be an asset protection trust, and this is a whole nother webinar on our website, by the way, we have to limit access and use of that money for the parent. So if you took $5,000 a month from the irrevocable asset protection trust and paid the assisted living for mom, that will destroy the trust. That's bad. When we're funding these types of trusts with families, deciding what assets go in and what don't, we typically have the irrevocable trust set up with real estate or a larger chunk of financial accounts, but we like to have another chunk of accounts go directly to a child, a trusted child, in what we call a slush fund. It's a gifted account. It's a separate account. We just call it a slush fund. So if there is, for example, like I said a moment ago, a $500,000 home and $500,000 in investments, the real estate goes into the trust. Perhaps $300,000 or $400,000 goes into the trust, and that other $100,000 or $200,000 goes to the trusted child as this slush fund. And that is how you would pay the assisted living, not directly, but rather it's a gift back to mom and dad. Okay, so if that child is holding the money and $5,000 is needed, you do not pay the assisted living directly. You give the money back to mom and dad directly, and then you pay the assisted living. That's how the scenario works. Okay, and again, this isn't, of course, specific advice for you. It's just educational in nature for all you folks that are listening. Okay, so hopefully, again, that answers the question. Boy, this is. I actually thought we'd going to run out of questions early, but we're going to keep going. From Denise, my mother's house is in an irrevocable trust under my brother's and my name as trustees, I'd presume. Now she's going to be moving into an apartment. She has assets. What are the implications for her to sell the home to purchase a new apartment and to purchase an apartment versus using her assets to purchase it? So generally speaking, if the irrevocable trust is done properly, there is flexibility as far as selling the home and buying a new property. And again, if it's done properly, then at the closing, the trustee is signing the deed, transferring the home out to the buyer. And then the buyer is paying their sales money to the trustee, and the money goes into the trust. It's direct, it's continuous. There's no new 5 years. There's no new trust necessarily involved at all, as long as it's done properly. So once that money, the sales proceeds are in the trust, that trustee can use it to purchase another apartment. Typically, it's a condo or a home. When people say apartment, to me, that might mean a co-op. You got to be careful because not all co-ops accept these types of trusts. So talk to the co-op board as to whether they will allow an irrevocable trust such as this that you're talking about as the actual purchaser, okay? If there are other monies, like I was sharing earlier, that kind of slush fund, yes, you can give money back to mom and you can use that as the down payment. And then again, you want the trust to be the actual purchaser. I will share that it's one of the more complicated things because we've had clients where they don't have funds for a down payment until they sell the property. So can they use other money for the down payment? All of that depends on the circumstances. So when we're engaged and we're working with a family as a client, then that's where we can actually analyze all of the scenarios, all of the relative factors, and come up with the best advice, okay? Again, this is just really general in nature. So I hope that kind of guides you, Denise, as far as an answer. My mother qualifies. Okay, my mother qualifies for the nursing home transitions waiver that we were talking about earlier. The MLTC refuses her to give more hours. Of the 18 service contacts. Okay, so William, what you're dealing there with is unfortunately the reality of the situation. If you are looking to switch from MLTC to nursing home transition, then that should not only be the aides, but that should be bringing in nurses as well as other supervisors and other benefits. So talk to specifically the coordination agency you're referring to, and you may have to really just sever the ties with the MLTC to move over to the NHTD. If you are in fact a client of ours, then talk to your care coordinator and we'll help you do that. The reality of not having staffing, though, not having the aides is unfortunately true for many families. It is a heck of a lot better this year than it was last year. Last year, as you can imagine, aides were also receiving or being infected with the virus. The aides and the companions were under quarantine as well. And we're still dealing with some residual of that, perhaps for those reasons or other reasons. And we're just hoping and praying that a lot of these aides and companions get back to work so that we can completely staff our cases. We've had a handful of clients, as all elder law attorneys have, struggle with this. So unfortunately, it's not unique, but again, we're hoping that it's going to end soon. But again, William, the idea of MLTC to nursing home transitions, definitely doable. You might be just running into the practical staffing problem. Owen, is it unwise to establish, or rather, forgive me, wrong word. Is it unwise to name a trust as a beneficiary of a retirement plan? Good. Again, it's kind of switching back to the estate planning side. Trusts are great for many, many reasons. You have revocable trusts, you have irrevocable trusts. Retirement accounts like IRAs and 401ks. 401ks, not so much, because you usually need to leave that to a spouse. After that spouse is no longer there, deceased, then you can leave it to others. Naming an IRA or rolling out the 401k to an IRA gives you a little more flexibility, as far as I know from financial professionals. Is it wise to name a trust as a beneficiary of a retirement plan? It depends on the circumstances, Owen. Retirement accounts have very specific payout rules. They were confusing and specific prior to 2019, and then the Secure Act was unleashed, and now we're dealing with 10-year payouts versus that stretch account that we used to enjoy for every beneficiary. The reality is, when you have a trust as a beneficiary, you can have what's called a conduit trust, or you can have what's called an accumulation trust. You do trusts for beneficiaries for different reasons. Is there a disability? Are they a minor? Are they not good with money? Are there potential divorce issues? Are they spendthrifts? So the idea of a trust can be used. You just have to be careful as to how it's structured, as accumulation or as conduit, okay? So I'm not going to say it's unwise to name a trust. I'm just going to say you have to do it for the right reasons, and you have to do it the right way, okay? There has to be the right type of trust, all right, with the right language built into it, all right? The worst case scenario is you're stuck with a 5-year payout. If the trust doesn't qualify as a proper trust, as a proper designated beneficiary, then again, you'll end up with a 5-year benefit, or forgive me, a 5-year payout on the IRA proceeds. Next question is from Kat. So if I own my mom's car, joint with survivorship, so child and mom own the car together, God forbid there's a car accident, will they both be sued? The answer is yes. We don't do personal injury litigation or defense, but I know people who have. And the reality is they're going to cast as wide a net as possible and get the owners of the car included. So yes, there's a risk there. You can mitigate that risk perhaps by having sufficient car insurance, liability insurance, comprehensive coverage. Are there other disadvantages to joint with survivorship? Other than a car, if you're looking at financial accounts, there are always risks in naming a child on an account or giving them money, for example. The way I explain it is the use of the D's, okay? There's a list of things that begin with D that can be detrimental to the loved one's money. If the joint owner or the money holder dies, or if they go through a divorce, they suffer from dementia, or they're disabled. If they do something dumb, that's my favorite, meaning they spend it, or they have a creditor come after it, debt. So there are always risks when you have a joint account with somebody, and there are always risks if you have somebody hold your assets for you, all right? Hopefully that answers your question. Last question for today, until I'll go check the chat box. How can I get a power of attorney away from a person? Good question. So a power of attorney is revocable, generally speaking. So you can issue a revocation of the power of attorney and provide that written revocation signed and notarized to the different financial accounts that are using it, and mail it out to the actual power of attorney agent, notifying them of the revocation. Or you can sign a new power of attorney that, most of them say this, you'd have to verify, that will automatically revoke the prior power of attorney. You still want to tell them, you still want to tell the banks, okay? The sad reality is, if there's a real contest with the power of attorney, or there's dueling powers of attorney because the second didn't revoke the first, or the first power of attorney agent is not doing right by mom or dad, then you may end up in a guardianship proceeding, okay, as I was referencing earlier. You don't want to do that. You want a power of attorney to be the proper way to handle your loved one's affairs, okay? But there is a way to revoke it. You know, generally speaking, again, financial institutions are only supposed to be working with original power of attorney documents. So if the agent doesn't have that, they shouldn't be acting on, or shouldn't be allowed to act on, the principal's behalf at all. All right. So Emily, I hope that was helpful. I'm grateful that we were able to put this together in this new platform, in this new way. And we've got questions in the chat. So let me check as we start to run out of time here. Will you be able to? So I think the question from Elizabeth is, are we able to do home appointments or assisted living appointments? Over the last year, as you can imagine, things were mostly Zoom. For the last 10 months, clients have been coming into the office. We're probably about 60% of the client, 60 to 70% of client meetings are in office. Yes, we do have the ability to do home appointments. It's not just me here, gratefully. I have a team of attorneys and advocates and paralegals and so forth. So if a home appointment was necessary, if my schedule precluded that, then real qualified, able attorneys can help with a home appointment. What is the maximum income a person can have? Okay, so what a Medicaid question there. If you're looking at Medicaid eligibility is about three things: assets, income, and care. On the income side, when somebody goes into a nursing home, the maximum they can have is $50. Plus health insurance, you usually keep your supplement, et cetera. The balance goes to the facility. In some exceptions, it can go to the spouse. If it's a home care scenario, it is a $904 number. They let you keep more, but it's still not sufficient to live in the community alone. Therefore, we're able to use a tool called a pooled supplemental needs trust to shelter the excess income over the 904, and again, over the premium amounts for health insurance. So there are ways to shelter in a home care scenario, sometimes in nursing home. Okay, so yes, thank you, Denise, for the clarification. So it's still a home appointment. So whether we go to a continuing care retirement community such as that, or a home, apartment, or a house, yes, we can do that. Sometimes fees are a little bit different because the time allocated to do such a thing, but it is certainly possible. Okay. So thank you, Denise, for clarifying that. I don't see other questions, so I'm going to say thank you very much. A real pleasure. Join us next Wednesday as we continue on with our navigating the second half. I'll have a discussion with a home care agency, and we'll be able to discuss what's been going on with home care in the last 12 months. What are the pros, the cons, and what does it look like moving forward? All right. Again, thank you for joining us. Thank you for your questions, and we will see you soon. If you have anything that we can help with, reach out to us. Give us a call. I actually like to put my phone number up here, so let me do that. Where are we? There we go. So if you have any questions, you can email me directly, brian@tullyelderlaw.com, or call us directly at the office, 631-424-2800, 424-2800. We do offer free consultations to assist with the planning and or the protection, and of course the care needs, the Medicaid work, et cetera. Thank you and have a great day. There we go. Good. Okay, bye.